I was asked to present on the Caribbean Court of Justice and its role in the implementation of the single market and economy. So there's a lot that can be said about the Caribbean Court of Justice and the pivotal role or perception it has in terms of the Caribbean community. My presentation will focus primarily on the original jurisdiction, since that is where the direct relationship the CCJ has with the CARICOM single market and economy. If there are other questions, I can perhaps deal with those as well. I think the idea is for this to be a very interactive session. But I will be looking at the mandate of the CCJ in relation to the CSME, which stems with the original jurisdiction, looking at the development of some of the jurisprudence in relation to the revised treaty, how it affects the implementation of the CSME, and focusing on a couple of those cases. There's a lot that can be said about the Caribbean Court of Justice in terms of the background and the history. And you can read, there was a lot that was said before the CCJ was operational. And so I'm not going to go into too much detail on that. The CCJ was established by an intergovernmental agreement that entered into force in 2002. There are 12 parties to the CCJ, and those parties are Antigua and Barbuda, Bahamas, Barbados, Dominica, Grenada, Jamaica, St. Lucia, St. Kitts and Nevis, St. Vincent and the Grenadines, Guyana, Suriname, Trinidad and Tobago. I hope I have reached 12. Those countries were the original countries who were moving forward with the CARICOM single market and economy. One of the main objectives of establishing the single market and economy, I've quoted there, where the heads of government were convinced that the Caribbean Court of Justice will have a determinative role in the further development of Caribbean jurisprudence. The court was established with two jurisdictions: the appellate jurisdiction, in which it will function as the highest national court for those countries that have accepted this jurisdiction, and the original jurisdiction, which derives from the treaty establishing CARICOM. The appellate jurisdiction both jurisdictions are in fact very distinct. One is in the national sphere, as I mentioned, and the other, the CCJ, functions as an international court with a treaty-based jurisdiction. The CCJ in its appellate jurisdiction is the final court of appeal for Barbados, Belize, and Guyana thus far. Other countries have indicated that they're moving towards implementing the appellate jurisdiction of the court. It is distinct from the original jurisdiction, even though the panel comprises the same judges. They function, when they act as the final court of appeal for Barbados, that is what they are, the final court of appeal for Barbados, and similarly Belize and Guyana. It is really a symbol of independence, in that most of the Commonwealth Caribbean countries, when the idea came up for the development of a Caribbean Court of Appeal was the focus. It was to move away from one last remaining link to the United Kingdom in terms of the Privy Council. So the CCJ has been touted as, a symbol of our further independence and growth to develop our own jurisprudence, our own institutions. But it really is distinct from the original jurisdiction. It applies national laws. It does not apply treaty law. And so in that respect, my presentation is not going to focus much on this jurisdiction. There are perhaps some expected or consequential benefits of having a joint final court of appeal in the development of Caribbean jurisprudence, where you have the same judges, where in fact decisions may be based on similar laws. Perhaps there may be a harmonization coming from that route, but it is not the main goal. That, of course, is my view, and there may be other views as to how the appellate jurisdiction functions in the integration movement. The original jurisdiction, the court, is really the court of the community. It is not one of the institutions of the community that is named in Article 21 of the revised treaty, if you've looked at the structure of the community. It's not an organ or body or council, but it is in fact the court of the community, which is a separate and distinct role that it plays. It was established by the agreement prior to the revised treaty entering into force. It was established by a separate agreement because it was in fact creating two jurisdictions. But the jurisdiction in relation to CARICOM and the revised treaty is founded in the revised Treaty of Chaguaramas. It is a compulsory and exclusive jurisdiction in respect of the interpretation and application of the revised treaty. As part of this compulsory and exclusive jurisdiction, there's a requirement that if a question comes up in the national courts that relates to the interpretation or application of the revised treaty, that question must be referred to the CCJ to give its ruling on it. The CCJ can also provide advisory opinions upon request by member states or the community in relation to the interpretation of application of the revised treaty. Parties to a dispute may be member states, the community, or persons who are regulated under Article 222 of the revised treaty in terms of the requirements that you must meet to bring an action against a member state or the community before the court. This establishing a court which has compulsory and exclusive jurisdiction, which provides for compliance by member states with the judgments of the court, which provides, as interpreted by the court, for consequential remedies or orders that the court may give in a judgment, is really an important step in the evolution of the community as an international organization. The revision of the treaty, which was completed in 2001, revised the 1973 treaty to create more formal structures of CARICOM and decision-making processes which provided that ministerial councils could take decisions by majority vote, which was distinct from the previous scenario where really decisions were taken by consensus. Now, the heads of government still take decisions by consensus, and in practice, many decisions may in fact be taken by consensus, but the fact is the treaty provides for a formal decision-making process, which is generally regarded as a sort of maturity in development of international organization, moving away from where you require unanimity to take action as an international organization to majority decision-making. Correspondingly with that is providing an entire dispute settlement mechanism, which is set out in Chapter 9 of the revised treaty. And the culmination of that is the court, which has been the most active of those dispute settlement mechanisms, and certainly the most formal in the experience of the community. So when we look at what is the role that the CCJ then plays in relation to the CSME, we have to have an appreciation of what is the CARICOM Single Market and Economy. The CARICOM Single Market and Economy is established by that revised treaty, which the CCJ is set up to interpret and apply, or give the guidance to jurisprudence on the interpretation and application of those provisions. So I've set out here in the presentation, but I'm not going to go into all of this. Essentially, it's a single large market among the participating member states, providing opportunities to produce and sell goods and services and to attract investment. There's some objectives that are set out in the revised treaty, against which the regimes of the single market would be established. Some of the elements of the single market can be identified as free movement of goods and services, right of establishment, common external tariff, free circulation of goods, free movement of capital, a common trade policy, free movement of labor. I've also put a note in terms of free movement of people and the single economy, because these are goals that are set out in the revised treaty, but they have not necessarily been elaborated or been full-fledged regimes. Certainly in the single economy, that aspect still needs to be elaborated in more detail, and we're focusing on establishing the single market. In terms of the free movement of people, there is a goal in the revised treaty, and there are certain elements of that that have been implemented, such as movement of skilled nationals, movement of service providers, movement of persons who are seeking to establish business. Those come under Chapter 3. But full free movement of people has not yet been achieved in CARICOM, and that we're still under progress in that. But of course, coming later in this presentation, we'll look at one of the most recent judgments of the court, which sets out the scope of what currently is the status of free movement and the obligations and rights arising out of the treaty. So CARICOM is a rule-based system. I've spoken of the CCJ as being one of the features of a more developed or more mature international organization in terms of decision-making, governance arrangements, and the formal adjudication process. The court recognized this in TCL against the Caribbean community, which was the first case challenging the community itself. And there's a quote here that is often referred to in the few years that the court has come out with this judgment, indicating that by signing and ratifying the revised treaty and thereby conferring on this court ipso facto compulsory and exclusive jurisdiction, the member states transformed the erstwhile voluntary arrangements in CARICOM into a rule-based system, thus creating and accepting a regional system under the rule of law. The rule of law brings with it legal certainty and protection of rights of states and individuals alike, but at the same time of necessity, it creates legal accountability. And I think this really sets out the parameters of what you look at in terms of what is the role of the CCJ in terms of the implementation of the CSME or the implementation of any of the provisions of the revised treaty and the operations of the community. We're looking at legal certainty in the interpretation and application of the regimes of the CSME. I know that there were some of the participants here who have a legal background, who may be attorneys, whether they be private sector or public. And for many years, until we started getting the first cases in the original jurisdiction, it was difficult to function completely as an attorney representing the community and advising the community when you didn't have that essential, what is considered essential, which is the jurisprudence, the guidance from the court in terms of what do legal provisions mean, what is legal status, what is the effect. So the CCJ has added to that to allow us to really truly appreciate the extent and provide guidelines even in our work, but also in terms of the operations of member states and the community organs and bodies in how they function. Legal certainty in the interpretation and application of regimes of the CSME is, of course, of particular importance to private sector as well. If you want to attract investment, if you want to have people investing and benefiting or willing, wanting to provide services, set up businesses, etc., within CARICOM, which is one of the goals of the community and this integration process. These people need to know that there's some certainty in how the rules will be applied, how the regimes will be implemented. Further to that, the CCJ, in speaking to the rule of law that governs the community, this protects the rights of states and individuals, and that certainly can be seen, certainly in terms of protection of rights of individuals, in applying to the court for enforcement or for settlement of a dispute or interpretation of a particular provision or implementation of a regime, and legal accountability of the member states and the community. Legal accountability is particularly important because member states have signed on to a binding legal instrument, binding an international law. They have also incorporated it into their domestic legislation and even implemented specific legislation in respect of movement of factors or the service providers, the right of establishment. They've removed restrictions on the ability of nationals to enjoy these rights and benefits of the treaty. And all this is in the national law thus far. The CCJ provides an avenue for legal accountability. And I know this is particularly of interest to the community, whether it be nationals or governments, because the treaty itself, when we were negotiating the revised treaty, there were no sanction provisions put into the treaty. But there was this formal adjudication process, and you can look at that to see how the CCJ can therefore provide that legal accountability, perhaps enforcement. And you can see that role of the CCJ in terms of the providing these benefits in relation to the implementation of CSME regimes. When you look at some of the original jurisdiction cases that have been before the court, which deal with these regimes. The jurisprudence coming out of the original jurisdiction, and you should know that all of the judgments, whether it be at the special leave stage or final judgments, are available online at the CaribbeanCourtofJustice.org. For many of the matters, particularly the more recent ones, the audio and video recordings are also available of the actual hearings. And so if you're interested in seeing how some of these submissions and matters played out, you can always go onto the website and view some of these proceedings. The jurisprudence coming out of the court has clarified areas that I've listed here, such as the jurisdiction of the court. The jurisdiction of the court, which is exclusive and compulsory, as we said before, in determining disputes concerning the interpretation and application of the court of the revised treaty, that comes from Article 211. But the court has also held that it can review community decisions. In fact, in the most recent case, Shanique Myrie and Barbados and Jamaica, it held that decisions, valid and binding decisions of community organs, constitute almost secondary legislation in this field of community law, particularly when they were in furtherance of the objectives or provisions in the revised treaty. So the revised treaty is the primary law. You may have some other related treaties or protocols. The court hasn't really looked at those yet. They've looked at rules governing, for example, the operation of the CET, but they've clearly stated that community decisions form that secondary part of the community law. We've also gotten jurisprudence on the status of parties and locus standi before the court, particularly looking at the access to the court by persons, whether it be natural or legal persons, and what are the requirements they must meet to bring an action against a member state or the community. And in fact, that is, all of the cases have been, thus far in the original jurisdiction, have actually been brought by persons. The court has given, and if you're looking at parties and locus standi, of course, the TCL against Guyana is a judgment that you would want to look at, particularly the special leave decision, because that was the first case where the court granted special leave to a person, in this case, a legal person, TCL and TCL Guyana Incorporated, to bring a case against the government of Guyana. And the court, for the first time, had to examine what were the requirements that had to be met under Article 222 of the revised treaty. They also indicated that 222 took precedence over whatever was stated in the agreement establishing the CCJ, and that is the sort of go-to case to look at to see what needs to be, what are the requirements to be met. The court has also looked at applicable law. Applicable law for the court. The revised treaty indicates that the court, as in its original jurisdiction, will apply principles of international law. The TCL and CARICOM case is a good judgment to look at to see how the court determined what was applicable law. They also examined it in TCL and Guyana. Principles of international law, principles of customary international law, principles of law common to states, and in particular principles of law that were common to CARICOM member states. In TCL and Guyana and TCL and CARICOM, they were really looking at judicial review, for example, and what principles of law in relation to judicial review would apply. And so it's interesting to read there to see how they determined judicial review can't just simply be the exact same thing as you would find in your national law, because you're now operating under international law. In the Shanique Myrie case, they also indicated that they don't, while their jurisdiction does not cover breaches of fundamental human rights, because those aren't contained in the revised treaty. Insofar as fundamental human rights are a part of the body of principles of international law, they can be relied upon in terms of guidance in taking a decision, but not as a cause of action in its own right. The court has also given guidelines in terms of the standard and burden of proof, and always drawing the distinction between between national courts, national laws, and what must happen for the CCJ as an international court. I mentioned judicial review and the guidelines it has given. The court has reviewed decisions of the Secretary General, decisions of the Council for Trade and Economic Development as an organ of the community, and has held that this is part of its function, to review those decisions and actions of the community, whether it be the SG, the COTED, the conference, to determine whether they are in compliance with the law, in this case, the revised treaty. We've also gotten decisions in terms of the status of what the community decisions. As I said previously, community decisions, if they're valid and binding, are regarded as secondary legislation, and we'll speak a little bit more on that later. The court has indicated what remedies that it sees itself able to offer. Declarations, yes, in terms of breach of the status of a regime or law. Orders, including coercive orders, because they said since Article 215 requires member states to comply with orders of the court, that means that they can then issue orders such as they did in TCL and Guyana, requiring a member state to, they also did it in Hummingbird Rice Mills, well, they would have done it if Suriname had not complied. But they would have given orders requiring a member state to comply with the law. In TCL and Guyana, it was in terms of applying the common external tariff, which member states are obliged to maintain in pursuant to Article 82 of the revised treaty. I have here a list of the cases that have been brought before the CCJ in the original jurisdiction. They've included cases against a community institution, a member state, the community, and a treaty entity. And those are judgments that you can all check. Doreen Johnson and CARICAD specialty was not granted because the court, in looking at a relationship between CARICAD and the community as defined from the revised treaty, didn't find that sufficient nexus to bring it within the jurisdiction of the court. TCL and Guyana, I spoke some about that. That was a case in relation to the obligation of a member state to apply a common external tariff to goods of extra-regional origin. TCL and CARICOM, the first case where the community was actually a party to a matter, was a challenge to the decisions by the Secretary General and the COTED in terms of suspensions of the common external tariff, and whether that was in accordance with the treaty and the rules of the community. Hummingbird Rice Mills against Suriname and CARICOM was also in relation to the CET and the non-application of the CET by Suriname in relation to extra-regional flour. Shanique Myrie and Barbados looked at and Jamaica as intervener, looked at what was the free movement obligation and then rights available to nationals. TCL and CARICOM Competition Commission. The Competition Commission is an entity created under the treaty, and it also, the CCJ has jurisdiction in terms of appeals from decisions of the CCJ, but also in this case, they reviewed the actions of the Competition Commission, the rules governing the Competition Commission, or the rules established by the Competition Commission for its operations, and gave guidance there. Then there are currently two cases that are before the court. One, Maurice Tomlinson, the court had just heard the special leave application has reserved its judgment, that is in relation to free movement or the immigration laws of those countries, and Rhodesia Beverages and Guyana, which is dealing with compliance again with the revised treaty. So you can see that the original jurisdiction cases have been initiated by natural or legal persons. What does this mean? It means that as yet, member states have not really accessed the formal dispute settlement mechanisms. We're still a very small community, very close community, and there's still a lot of matters or disputes that are try to be settled in terms of discussions without going to the formal adjudication. However, the CCJ in the original jurisdiction has provided that avenue for nationals or persons to be able to access the court to get justice. It affirms the intent of the treaty that benefits would accrue directly to community nationals. And not only would the benefits accrue directly, but that they would be able to seek enforcement in relation to those benefits. And of course, we've gotten much dicta in terms of the interpretation of Article 211 and 222 on the requirements to be met by private individuals to access the court. I'm just going to look at some couple specific regimes that the court has given us jurisprudence on. The common external tariff has been the subject of 3 cases: TCL and Guyana, TCL and CARICOM, Hummingbird Rice Mills, and Suriname and the Caribbean Community. And as I said, we'll keep saying those judgments are available online. The common external tariff is established by Articles 82 and 83 of the revised treaty. 82 states that there's an obligation of member states to maintain a common external tariff, and that means you have a common external tariff where every country must maintain and apply whatever is the CARICOM CET rate in relation to goods imported from outside of CARICOM. And Article 83 provides the route by which it provides the management or oversight of the CET and the operations by the COTED. So this is actually a community-managed regime, and the COTED is the authority that can decide to suspend the CET on application by member states, and there's a limited authority for the Secretary General also to suspend the CET upon the conditions set out in the treaty. The court has held that the CET is an obligation of member states pursuant to the revised treaty. They've also held that it is a benefit created by the treaty, which inures directly to community producers. This makes it easy in terms of the CET because it has been clearly established that this is a benefit that will meet the requirements of Article 222 because it inures directly to the benefit of the community producers, and therefore failure by member states to meet their obligation, member states or the community to meet the obligations in relation to the CET can be subject to judicial review or challenge before the court. The court also confirmed that it can review the role and decisions of the COTED and the Secretary General in relation to the CET. They also reviewed the rules concerning the operation of the CET. And if we look at, in particular, TCL and CARICOM, you can see some of the specific decisions that were taken in that case that shows that the CCJ really provided some of the some further building blocks in the operations of this important CSME regime. So the CCJ can review decisions of member states and of the community. The CCJ can grant appropriate relief, including coercive remedies. The CCJ recognized that the COTED must, and by extension, community organs and bodies must have some level of flexibility given that they're dealing with important national matters, needs, concerns, but that they must be accountable and operate within the rule of law. And so suspensions of the CET must only be granted upon the conditions met in Article 83.2, which currently state that you can only suspend the CET if there's insufficient quantity to meet the demand of a particular product, if the quality of the product is not up to standards. The court also stated that there is a duty both at the domestic and international level to ensure that all processes involved in making and determining requests for the reduction or suspension of rates under the CET should be transparent and efficient. This is particularly important because you're dealing with a regime with decisions that have an direct impact on producers in the region who have a guaranteed market for their goods within the CSME. That is somewhat protected because competing goods from outside of the region would be subjected to a CET. Some of the things that the court said in relation to the rules operating the CET, as I said, it should be transparent and efficient. Based on the details of that decision, the community reviewed its rules because the court said these rules were in operation prior to the revised treaty. And the revised treaty, as I had said before, brought into play majority decision making, an obligation to consult before decisions are taken. And the court said the principle of legal accountability. And the court said based on all of that, the way that we conduct business has changed. And therefore, in taking decisions which have this impact, such as suspending the rate of the CET in relation to extra-regional goods, they must be based on information provided. They must be transparent. You must abide by the reasons. As a way of an example, there was a practice that the Secretary General, on receiving a request for suspension, would consult with member states, and member states would indicate a no objection or an objection. And the court said it can't be an objection or no objection. You must have reasons. So you must indicate, can you meet the demand? Can you meet the demand? If a country is saying that I cannot get sufficient cement to meet my demands from the regional producers, and therefore I need to export it from outside the region, and I want a suspension of the CET for that end. A country who's objecting to that must say, I object to that because my producer can meet that demand. So you must be transparent, you must provide information. They also indicated that the SGO decoded should find out from the known producers or the countries where the known producers are for a particular good. So this all helps us in terms of operation. It means that there are more requirements to be met, but at the end of the day, it provides that certainty and accountability for the producers who benefit from this decision. Free movement. This is a particularly big one because it's the most recent case, but it's an important element of the CSME, even if it is not fully realized in terms of full free movement of all CARICOM nationals. This case, which was brought by a national of Jamaica against the government of Barbados, and the government of Jamaica intervened and was able, therefore, to bring evidence and make submissions. I should say that in all of the cases, the community, obviously where the community is involved as a party, you have to be represented as a party. But in many of the original jurisdiction cases, the community has had to be involved at least to provide records of meetings, records of decisions. There are orders of discovery made in relation to documents held by the community. And in cases such as the first case, TCL and Guyana, and in this case, Shanique Myrie, because of the fundamental nature of the case, the community made legal submissions in those cases. So the court held that free movement of community nationals is a fundamental principle of community law. It's set out in Chapter 3, particularly Article 45, and although they recognized that it was not fully realized, they said there were several regimes that showed that it was being fleshed out. There were elements of free movement in the community. Because it's a fundamental principle, they also said exceptions to the principle must be interpreted narrowly and strictly in order to avoid an unjustified watering down of the importance of the right it seeks to limit. They also made a statement that the revised Treaty of Chaguaramas and more particularly the 2007 conference decision, upon which this case is based, brought about a fundamental change in the legal landscape of immigration throughout the community. And in this, they're speaking to the fact that the approach to CARICOM nationals, because of what is stated in the revised treaty and what was stated in the 2007 conference decision, means that the approach in terms of CARICOM nationals seeking to enter the country must be different than to other persons. What exactly does that court say? And this is where the court has clarified for us some elements of what is the CSME. The court has said that CARICOM nationals have a right of entry into another CARICOM country unless they qualify for refusal under the two exceptions set out in 2007 conference decision. Now, I want to say here that the court did not make this law. And unfortunately, I didn't put it in the slide, but I think maybe during the discussions I can pull up the quote and show you. The conference actually made a decision in 2007 that said, in order to bring a sense of belonging to the community, to community nationals should have a right of automatic stay in another CARICOM country, an automatic stay of 6 months, unless they're undesirable or to prevent a person from becoming a charge on the public funds. So it was not the CCJ who came up with these terms. It was actually the conference decision, and the court has set out how it should be interpreted and applied. So the exceptions to this right of entry are if the national is undesirable, and they've given a lot of guidance as to how you interpret undesirable. The person must represent a genuine, present, and sufficiently serious threat affecting one of the fundamental interests of society. There's a lot of, as I said, a lot of guidance given by the court speaking to the fact that it really should not be individual countries. Yes, you determine your threat. Immigration is still allowed. Countries are still allowed to determine what their threat is. But you must also always have community discussion on what are the principles guiding that assessment, so that you and if a member state is to determine that a particular kind of conduct is undesirable or represents a threat, it must be conduct of a kind that, if affected by your national and your jurisdiction, you would subject that person to sanctions or prosecution. So it can't be arbitrary just for the entry. And the court also gave a little guidance in terms of what you can determine, what immigration can determine in terms of preventing a person from becoming a charge on the public funds, but not as much as in terms of what is considered undesirable. So a CARICOM national coming into another CARICOM member state must still show a return ticket, because you're coming as a visitor and you're not coming to stay indefinitely. You can assess whether the person has sufficient funds for their stay, not for the 6-month period, but for their stay. But the court also said, persons can, you must take into consideration all possibilities. People could be coming with credit cards, with cash. They may have someone, they're staying with persons, etc. Now, if you're coming in under this right of entry, you get 6 months automatically. But that does not mean that you stay indefinitely or take up residence. It does not mean that you can work without permission, whether as a skilled national or with a work permit. It does not mean that you can just go about providing services or establishing a business just like that. You still must comply with community law and national law to conduct anything else. And so where there are other requirements for other activities, then you must meet those laws. There are also procedures in terms of the right of entry, and this is where the court has really given these procedures, which are more or less based on natural justice principles that we may recognize. If you are refused, you must be given written reasons for refusal. You must have an opportunity to challenge a decision, judicially preferably, but an administrative procedure would also be a good first step for member states to implement. Community national must also have a right and be informed of that right to consult an attorney at law, a consular official, and or a family member if they're being refused entry. Beyond just the free movement element, that decision is a good one to read through because it really looks at the community decision-making process. The case itself was based on a decision, the interpretation of a decision of the Conference of Heads of Government, not just although it may have stemmed or may be in furtherance of objectives of the revised treaty, particularly Article 45, it really was a decision of the conference that was subject to review. And the court held that in absence of anything else to the contrary, a decision of a community organ or body which is taken in fulfillment or furtherance of the revised Treaty of Chaguaramas or to achieve the objectives of the community is immediately binding at the community level. And it's a good practice to set a time frame for compliance, the court in making that decision, so that it's immediately binding, but you may have a time frame for when you expect compliance. This has some implications for community operations and by extension what may be required of member states. Because if you're taking a binding decision that is to be regarded as secondary legislation, you would want to have effective and sufficient consultation at the national level in relation to the scope of such a decision. For example, a recent decision by the Council for Trade and Economic Development related to amending the treaty in terms of the CET to provide some more clarity or scope for the operations of the COTED. And there was a lot of consultations leading up to that decision, and that must be reflected in the content of the decision as itself. To inform these decisions, you must have timely, accurate, and complete information submitted by member states to the CARICOM Secretariat. So this would, it would impose an obligation on member states to have the consultation at the national level because you need to know what is involved in any proposed decision. And if you have information to guide that decision or your take on that decision, this should be submitted timely and should be accurate. And this follows from some of the other CCJ decisions in relation to the CET, for example, indicated that decisions in relation to suspension of the CET must be based on sufficient information. In the Shanique Mary case, they indicated, just in terms of submission of information, that there should be statistics and data on the free movement to look at compliance. In decision making, if you want to have the best decision, then the Secretariat will also have an obligation to distribute in a timely manner papers and draft decisions to allow for that consultative process. And you must have reasonable and informed determinations in relation to the time frame. What would be required then to implement this decision, and therefore what is a reasonable time frame to set? I mean, by way of a historical example, the Granad's Declaration of 1989 said that we'd be implementing full free movement by 1992. But given the things that we needed to do, was that reasonable? We're still in the case of in development. The decision of the court also spoke to having the statistics on free movement of CARICOM nationals because it is of direct benefit and importance and relevance to CARICOM nationals, that these statistics should be submitted to the Secretariat and be published and available publicly. Similarly, decisions that have an impact on nationals should really be available for the public to see. One other issue of great importance, and I know it has sparked a lot of debate in the public mind, this concept of community law versus national law. The court said a valid decision of the community is immediately binding at the community level. They also said domestic legislation is not required for the creation of a legally binding right for community nationals at the community level. You'll notice I bolded and I keep emphasizing at the community level. Because as I said in the beginning of this presentation, the CCJ is an international court, regional court. It functions at the community level, not at the national level. And it provides that enforcement, yet again, at the community level. We always recognize there's the international plane, which creates obligations between member states. And the CCJ has brought nationals into that plane who can seek enforcement, but at the community level. It does not mean that a decision or treaty of CARICOM has immediate and direct effect in national law. For most of our countries, we still require the actual domestic legislation to be changed by member states. But what it would have done is community law, whether you sign a treaty or whether you take a decision in relation to the common external tariff, changing the rate, which is a decision that is taken by the Quartet. These community law elements establish an obligation for member states to comply with the treaty or decision. The action thereafter is member states, but you cannot, general principle of international law, you cannot rely on an absence of your national law to defend your failure to comply at the international level. So community law is enforceable at the community level. I do wish to note, and this is probably something people can look into some more, that the revised Treaty of Chaguaramas has actually been enacted into domestic legislation. What then is the status of provisions or obligations established in the revised treaty that now form part of your domestic legislation? In some cases, there have been specific pieces of legislation that have been passed, removal of restrictions in relation to provision of services or right of establishment, which specify that where it is clear that you are abiding by or complying with an obligation of the revised treaty to provide that community nationals receive the same treatment in terms of setting up a business. So there are those elements of community law that are already in the domestic plane, but they were done by domestic act. So in conclusion, and I hope I have not spoken too long, but as I said, there's a lot you can cover here. I will look back again at the topic that I was given, which is what is the role of the CCJ in the implementation of the CSME? And we can see that the CCJ provides definitive interpretations of the law, whether that be treaty or decisions, definitive interpretations, guidance on the application of that law, and what that law, does that law create an obligation for member states? Does it create a benefit for the nationals involved in the CSME? The CCJ provides dispute settlement, and it provides judicial review of the community actions in relation to the CSME and implementation of the revised treaty. It provides enforcement. The court has given coercive orders. It has given declarations on breach. It has given jurisprudence on what that it can order damages against a community or a member state, but certain requirements must be met. And so does this fill the gap in terms of the absence of sanctions in the revised treaty? To some extent it may, because it provides some enforcement. This is my view, but it'd be good to hear views on that. But at the same time, one of the issues that came up in the Hummingbird rice mills and Suriname and the community, that claimant sued Suriname for a breach of the revised treaty in not applying the CET on flour from the Netherlands. But they also sued CARICOM for saying that the Quartet acquiesced in that breach. Now, the court ended up determining that the Quartet did not acquiesce in that breach. We always considered it a breach. But in doing so, they recognized that there was nothing else the community could really have done to seek compliance with that obligation by Suriname or indeed any member state. And so that still exists, and it would require someone who's affected to actually go to court to get it, because there's nothing else the community can do. Whereas if the community were able to take definitive action without waiting for someone to go to court, perhaps it would maybe abbreviate the time for compliance. It is something that it's a continuing evolution of the community, and perhaps the court can help us as we go forward. That is the end of my presentation. I can hand over Joan. in relation to conducting
Right. Thank you very much, Safiya. Quite a lot of information has been presented, and we really appreciate your sharing that with us. And I want to remind all participants in the webinar this afternoon that there are two ways in which you can signal your intent to pose a question. You can do that by using the raise your hand feature, which can be found in the lower right-hand panel of your screen, or you can use the chat feature, also found in the right panel of your screen. I'm going to get the ball rolling by posing the first question to you, Safiya, and this question relates to the slide which you presented on the implications for community operations. And it stipulated that there should be effective and sufficient consultation at the national level. So what is the process currently utilized by the CARICOM Secretariat to ensure that such consultations occur? Or is it left completely to the member states to ensure that they meet the requirements?
That is something that sometimes changes depending on the nature of the consultations. The Secretariat does try to, the obligation for consultations is both. It's on the Secretariat as well as the member states, because it is up to the member states to indicate what is their national policy or position on a matter. What the Secretariat does is prepare papers, background, technical information to inform those consultations. And we'll do liaise with member states in terms of, do you need support for consultations on a particular issue? Any additional information? There have been consultations of the kind where, for example, even if you look at the establishment of the CCJ, that was a whole huge setup of consultations as well, where you actually go into member states to convene meetings of relevant stakeholders. You may not convene them, the member state may convene, but the Secretariat can go in and offer that additional technical assistance or guidance in terms of the consultations. It is a little difficult to institute, maybe it just has been difficult up to now, because the consultations we still operate in this mode of sovereignty and separation of community level versus national. So consultations can be a very national thing, and we just provide assistance upon request. I think the best thing the Secretariat can do is ensure that member states and officials are provided with all of the relevant information, briefs, guidance to inform those consultations. In timeliness, I think, is probably one of our biggest challenges. Both the Secretariat and on member states' end, but because you have so many stakeholders involved in some particular decisions that you really need to get information out there, data out there. One of the challenges the CCJ has found, they mentioned it in the CET cases, and it would have even come up in the Sinead Myrie case, is the fact that we still don't get we don't have formal data collection. We do have it, but we don't get compliance with some of the data being submitted that would inform consultations.
I'm actually going to open up now for Kizan Lisam to pose her question. Kizan, please go ahead.
Okay, I can see her question written in.
Yes.
What provisions are in place for MSME owners seeking to, I presume this is micro and small and medium enterprise owners, perhaps, seeking to conduct business in countries outside their residence? Example, huckster trading. How is this affected by the CSME structure, especially given your clarification given movement of persons? Well, you can provide services. You can move into a country to provide services, and the decision in relation to free movement, the right of entry, the automatic stay right of entry for CARICOM nationals will underpin any of the free movement regimes, because once you're a CARICOM national, this is what you should automatically get, regardless of the purpose of your visit. Once, of course, it is a legitimate, when I say legitimate, once you're not coming for illegal purposes. And that would include if you're coming up to set a business or if you're coming to provide services. Now, there may be other requirements you would have to meet if you are seeking to come as a skilled national, because because a skilled national is allowed to come in indefinitely and also to work with and seek employment and work without a work permit once you have a skilled national certificate. So that there may be other requirements you have to meet. But the free movement, this decision of a right of entry doesn't necessarily solve all of the problems in relation to, I note your example, Kizan, in relation to huckster trading and how people regard that. But hopefully it is still something we're looking at to see how far the decision extends. How we apply this regime to other elements of trading going on in the community. And I know that is not a complete answer.
Okay, and we encourage our other participants to join in as well. In the meantime, Safiya, you mentioned that there are certain procedures for the right of entry. My question is about timing and access to those procedures. Do the procedures take place after the person is returned to the home country? Because we're seeing entry being denied at the court. So what then is the recourse that the person would have in terms of accessing those procedures? And once Safiya is done with that, we'll come to you, David.
Yeah. Actually, these procedures and the slide that I have up there, it's really just should really happen at the point of refusal. For in the interest of justice, if you're being refused, you should be given written refusals at that point of refusal. And the opportunity to review judicially or access to some administrative scenario is really supposed to be in there, even in the country, because remember the idea behind review is that you want to get in, you want your right of entry exercised, and that can really only happen. It happens more effectively if you get the opportunity for a review when you are still in the country before you are actually sent back out. This is something that the community has started looking at how exactly it can be done. The government of Jamaica had indicated, and the court notes this in this decision, that it had some practices for administrative review at the point of refusal, which would mean applying to a particular senior officer or something like that. And the court said, until we determine and set up more formal review processes, we can look at the best practices of other countries and see how they're done, even our own other member states, and see what we can do administratively. So at least, because if you look at, the court takes you through the facts of what happened in terms of Shanique Mary, and so there were reasons that the court said, look, you need to be given written reasons for your refusal, and need to be given at the point of refusal, because you don't know what's going to happen between that time and when you leave. You need to know what the grounds are at that point. And that may forestall some of the complaints. And you also need, if you're going to be detained or, awaiting going back, you need to be able to consult with an attorney or a family member so that you can have access to justice or to know your rights. The court, however, made it clear that although it awarded damages in the Shanique Mary case, it did not award damages for unlawful detention or anything. They said those things are not causes of action before the court. The damages were in relation to the breach of the right of entry, how the right of entry was breached and the conduct there. So it didn't go that further. It's something we're still looking at. The community recently approved a complaints procedure in relation to the free movement regime, and that we'll start rolling out so that in addition to you being entitled to written refusals, an opportunity for you to file complaints, which will allow us to track what is going on in countries, because the statistics, it's not everybody being refused, and it's not people necessarily always being refused unjustly. So a complaints procedure will help us regulate that kind of in the interest of member states as well as the nationals who are seeking to exercise their rights.
Okay, thank you. And from David Lodat, we have a very open question, Safiya. I don't know how you're going to handle this. Please indicate whether the CCJ is lacking in any respect as it relates matters of its original jurisdiction.
Is it lacking? As a representative of an entity that has to appear before the CCJ in its original jurisdiction, this is something that I'm very wary about commenting on. But the court itself will tell you, I mean, you know, some of the judges have delivered, in academic fora and written to say that when faced with this original jurisdiction, they basically had to craft the rules from scratch, because they're international court, but they're operating with a smaller community. How they develop the rules, I think you can see it in the CET cases, and this is not a criticism of the court, because, like I said, I'm being wary in terms of the operations. But it took a while. There's some particular trade regimes. Even myself, as an attorney within the CARICOM Secretariat for a few years, we still really require a lot of technical advice in terms of the operations of something as complex as the trading goods regime, and particularly the common external tariff. But that being said, because the court functions as an international court, they do take the submissions, they do read it through, we've had, the community sometimes plays a strange role of both offering expert information as well as legal submissions, or in some cases, defense where we are a party. So perhaps if we get more cases in terms of the trade regime, we might need to have some more trade expertise, but not necessarily on the panel, but in terms of how we seek information. But the CCJ has fairly broad powers to request certain expertise and submissions being made to it, and they can come at the request of a party. But I can't say too much more than that. I don't think it would be appropriate for me.
Okay. Thank you, David, for the question, and Safiya for the response. We go now to Emil McGarrell. Emil, your mic is open. Emil? Okay, Emil, we're not hearing you coming through, so perhaps you can type your question into the chat box if you're having a difficulty with your audio. In the meantime, Safiya, I want to go to the matter of judicial review. Now, who exactly would have standing to challenge such decisions?
Well, the judicial review comes up in the general application to the court, the jurisdiction of the court in Article 211 of the revised treaty. It comes up, it has come up so far. Article 211 says that subject to this treaty, the court shall have compulsory and exclusive jurisdiction to hear and determine disputes concerning interpretation and application of the treaty, and it identifies disputes between the member states, disputes between the member states and the community, referrals from national courts, and applications by persons in accordance with Article 222. So in all of the cases, not all of the cases against the community so far, TCL and CARICOM, Hummingbird Rice Mills and Suriname, and the community were applications by persons in accordance with Article 222, and were actually seeking judicial review, essentially, of the court, by the court, of decisions of the SG or decisions of the quartet. So it comes up in relation to that general application where you're going before the court, making an application by a person to say, has the community acted in compliance with the law? And so the court reviews the decisions of the community, or whether they be taken by the SG or the quartet or the conference. Okay. We have not had disputes in that term going before the court in terms of a dispute between member states as to how that would be. A judicial review question could come up in such a scenario if you're looking at one member state, perhaps a member state lays a claim saying that another member state is applying a CET suspension that was wrongfully approved by the community. That would, obviously involve a review of the decision of the community in terms of the CET. But you can speculate like that. So far, because you've had applications by persons in terms of whether their rights or benefits have been prejudiced, that is how judicial review question has come up, looking at decisions of the community.
Okay. We have a question from Kareem Yard, and he wants to know if the CCJ has the capacity to analyze the unfair airline travel practices in the region. And he gives an example of a claim that Caribbean Airlines has unfair benefits which are not afforded to LIAT. And I suspect he's referring, at least in part, to fuel subsidy.
Fuel subsidy, yeah. I'm looking at that. That is currently, you can say that is currently a dispute between the member states who are shareholders of LIAT against the member state who is the beneficial owner of Caribbean Airlines, because it has come up, and those member states could go to court because, in fact, and I'm not speaking out of turn necessarily, because the Prime Minister, St. Vincent and the Grenadines, has actually made public statements indicating that those shareholders of LIAT have a legal opinion indicating that, in fact, some of the benefits that CAL gets from the government of Trinidad and Tobago may be in breach of the revised treaty, whether it be provisions in terms of discrimination, unfair conditions in terms of operating business, unfair competition. So there could be grounds, but it really is a dispute between the member states who have the interest in those two, and whether they choose to go to the CCJ on it. But I could see that you could get past the special leave, definitely, and then leave it and for the court to determine whether, in fact, there's any breach or how to determine that dispute.
Now, would a passenger on LIAT have local standi if the governments are not raising the issue, for them to come forward and bring a case saying that they are being disadvantaged by the breach?
I suppose they could. It would be interesting. It's interesting because what a passenger would have to prove is that there's something in the treaty that is supposed to inure directly to them. Now, you could have proven that in relation to the CET, because that clearly was a benefit to a producer of a particular good. The free movement could only be a benefit to CARICOM nationals. In terms of your rights, the difficulty I can see is that what would be the basis of your claim? If it's discrimination, you're not necessarily being discriminated on the basis of nationality, because it's depending on the routes or competition. You could say you're prejudiced in terms of your access to competitive transportation. I think it would be an interesting case to make. How successful it would be, because is it a benefit that's supposed to go to you directly or to the two air carriers who are supposed to be operating in fair competition with each other? And of course, that has fair competition should mean better prices or services for the national. Is that a direct enough link, or is it a case where if it's a consumer protection or competition issue that has been given a certain authority to the CARICOM Competition Commission? It's actually very interesting. I think you could probably go through that kind of reasoning, maybe to go to the court to get past a special leave. Whether it comes down to you being able to get a declaration, it's a little different, because I see that as a little more indirect than some of the other regimes, which are clearly for the benefit of nationals. This one may more be you want fair competition between the carriers and their conditions for operation.
We're coming to what is going to have to be our final question because we're at 4:29 p.m. We're scheduled to wrap up at 4:30. So I'm going to pose this final question, then I will give you the opportunity to share any closing thoughts, Safiya. And in the meantime, I'm going to open the poll so that persons can begin to respond to a very short poll. And the question from Emil is a request for clarification. He has indicated that he may have missed the aspect of the presentation where you explained the concept of community level. So he's asking if you could explain that concept for him, please.
Sure. Community level means at the level at which the member states operate together. We have a community structure which comprises the organs and bodies where the member states meet. So, and where they owe obligations to each other as member states. And the court operates in that sphere, that international law sphere. It's a court which applies rules of international law because its primary function is to determine disputes among international actors, member states, the community, and there is a window of access for nationals, but they're still seeking in relation to obligations at that international level. So the community level means to me, those organs or those spheres of operation which operate outside the national plane, which is the organs of CARICOM, including the court. The court functions in relation to the things set up by the treaty. So that is the community level, not going down individually to what happens in a domestic plane. Although at some point, lines could be blurred, as I had mentioned, that where you have the treaty in your domestic law, where you have laws that are clearly in compliance with your treaty obligations, to some extent that is an acceptance of community law within your national level. But the enforcement, strictly speaking, of obligations that member states have under a treaty or under a community decision is at the community level. So you take it to the conference, you take it to the CCG. Okay.
Okay. Just alerting the participants that the poll is now open, so we would ask you to proceed to answer the questions. And Safiya, do you have any closing thoughts you'd like to share?
Well, I'm sorry. My presentation took a little longer than it should have, and I did try to whittle it down. My closing thoughts is I think the CCJ I listed those cases that we have had. The CCJ was in operation since launched in 2005, 2006. We had the first cases starting in 2008. It's getting more and more active, primarily because of the community nationals who recognize the access there. But I think we have a lot more we can do. No advisory opinions have been requested yet of the court. Member states have not taken disputes yet. But certainly from the significant improvement we get in terms of the jurisprudence of the court, the guidance of the court, I think the original jurisdiction has really fulfilled its role in providing that certainty, that legal accountability. And although no one brought it up yet, no one spoke more to it, providing that enforcement mechanism in the absence of any other provision in the revised treaty. Enforcement as well as guidance, since the court can do that. And certainly from a secretariat perspective, whatever can help us in terms of advising the community or setting up structures to improve the operations of the community for the benefit of member states and nationals, the court certainly plays a very, very important role in that aspect.
Okay, thank you, Safiya. We actually have a few questions coming in that I'm going to crave your indulgence in order to accommodate them. And
Sure.
One relates to the availability of the PowerPoint presentation. Let me just reiterate that we have been recording the session. The recordings will be made available to all of you who are currently online, and you can also have other people access the recording. We will make it available via our website. Safiya, someone has asked if your presentation could be made available as well, the PowerPoint.
Yes, I will send it to you so you can share with the participants. That's not a problem.
Okay. And we have one additional question from Andrea Dawes, who's apologized. She said she joined us late, so she's asking. She says it seems to be that there is this impression that a member state requires a second member state to join it in order to bring an action. Is that correct?
What she's referring to is the the provision of Article 212 of the revised treaty, which says that the court shall have exclusive jurisdiction to deliver advisory opinions. And paragraph 2, advisory opinions shall be delivered only at the request of the member states parties to a dispute or the community. And it does seem to imply that in the treaty. I think the rules of the court in relation to advisory opinions do not necessarily limit it to requiring both member states to go for an advisory opinion. It is not something that has been the subject of a court ruling before. So that I can't speak definitively, but it does seem to suggest that, I could see a member state arguing that both parties to dispute should go forward to the court or not. I would have to check, quite frankly, the travaux préparatoires for this provision, which is the Intergovernmental Task Force, which met to revise the treaty and dealt with these provisions to see what was the discussion on it guiding that provision. I don't think the court rules, the rules for the original jurisdiction, require that both parties or all parties to a dispute make the request. But the court has already held that the revised treaty actually entered into force in 2006, later than that of the agreement establishing the CCG. So in that respect, the revised treaty and interpretation of the revised treaty would take precedence as a later treaty. But it's an interesting question because we've been that issue has come up in terms of requesting an advisory opinion. I think most member states, there have been a few discussions for the community to go forward with a request for an advisory opinion on behalf of the member states or in respect of an issue that has come up. So it is still something that, and this is one of the things that we look forward to. The more questions that go before the court, the clearer we can be on some of these issues. I'm certainly, when I leave this session, I'm going to look into what was said in that respect, the advisory opinions. But we have not accessed that aspect of the court yet. So it's merely speculative.
Okay, so I'm really glad I took that final question because we have something that's worthy of further consideration. So, ladies and gentlemen, we've come to the end of this webinar featuring Safiya Ali, General Counsel, Caribbean Community Secretariat. We thank you for joining us this afternoon. A special thanks to those of you who've already completed your poll. For those who are still working on the poll and have not yet started, you have an additional 4 minutes when it will remain open. So please proceed to answer the questions. Your feedback is extremely important to us. Safiya, I want to, on behalf of the Caribbean Leadership Project, say a very special thank you for responding so quickly and so favorably to our request for collaboration on this webinar. And we look forward to working with you again in the future.
Thank you very much, Joan. I enjoyed it. I hope that I presented on issues of interest to the broad range of people who signed up for this. But there can always be another time for more specific questions. I'm willing.
Okay. So again, thank you and goodbye. For those taking the poll, remember you do have an additional few moments where you can continue. For those who completed the poll, you may leave the session at this time.